Assalamualaikum warahmatullahi wabarakatuh. My name is Natasha Diana binti Azmi. I'm from DAT3C. My matric number 14 DAT3C F1005.
My name is Nur Fatiha binti Zafarizan. My matric number is 14 DAT19F1009.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nurdamia binti Saidin. I'm from DAT3C. My matrix number is 14DAT19F1029.
Okay, now I will tell you what the problem that Peekaboo Senior Berhad had to face. The problem in Peekaboo Senior Berhad are most of its corporate check written unpaid due to insufficient cash flow. The company cannot pay monthly overhead costs. In addition to, the members disagreed as they felt that the situation was not that bad. However, the board reviewed that the condition may deteriorate in the future if they did not dissolve the company. Okay, next, the solution that I suggest to the company is to use the compulsory winding up by court. Okay, compulsory winding up. A company can be legally forced to wind up by a court order. In such case, the company is ordered to appoint a liquidator to manage the sale of assets and distribution of the proceeds to creditors. The court order is often triggered by a suit brought by the company's creditors. They are often the first to realize that a company is insolvent because their bill have remained unpaid. In other cases, the winding up is the final conclusion of a bankruptcy proceeding, which can involve creditors trying to recoup money owned by the company. In any case, a company may not have sufficient assets to satisfy all of its debtors entirely, and the creditors will face an economic loss. Now, in the compulsory winding up by court, it have reason. For example, in the section 4651A of the Companies Act 2016, the company has by special resolution resolved that the company is to be wound up by the court. In the section 4651D of Companies Act 2016, the company has no member and many more. Based on the company, Peekaboo Senior Berhad has to winding up their company because its corporate checks written unpaid due to insufficient cash flow. According to the section 4651E Companies Act 2016, the company is unable to pay its debts. Okay, next, a company is deemed to be unable to pay its debt if any of the following conditions are met. First, the company is indebted in a sum exceeding the prescribed amount and a creditor has served a notice on the company at its registered office giving it 21 days to pay the sum. Second, it is proved to the satisfaction of the court of the company is unable to pay its debts. And third, the execution or other process required under a judgment, decree or order from any court is not carried out in whole or in part. So, this is the reason why Peekaboo Senior Berhad should winding up their company even majority of their members disagree. Then, compulsory court order winding up is typically instituted by a creditor if the company is unable to pay its debt. In the case of winding up under the just and equitable ground, it is typically instituted by at least one member of the company when the affairs of the company have been carried out in the director's own interest rather than the member as a whole, or in a manner which is unfair or unjust to members. So, both processes require the filing of a petition against the company in the High Court.
Procedure for compulsory winding up. 1. A notice of demand by virtue of Section 465 of the Companies Acta 2016 to be served on the company, demanding the company to settle its outstanding debt. 2. Necessary legal documents are to be filed in court. This includes the winding up petition if the company feels to settle the debts as per the notice of demand above. 3. Due notification will be given by the court on date of hearing. 4. The court is to decide on whether or not to grant a winding up order. If a winding up is granted by the court will either appoint a Director General of Insolvent (DGI) or a liquidator to wind up the company in question. 6. The appointed GDI or liquidator takes over all affairs of the company and proceed with winding up.
Okay, next is the person who has lodged standing in the compulsory winding up. Okay, in section 464 of Companies Acta 2016, 1. A company, whether or not it is being wound up voluntary, may be wound up under an order of the court on the petitions of any one or more of the following: A. The company. B. Any creditor, including a contingent or prospective creditor of the company. C. A contributory or any person who is the personal representative of a deceased contributions, or the trustee in the bankruptcy, or the Director General. D. The liquidator. E. The minister on the ground specific in the paragraph 465(1)(d) or (1). In F, in this case of a company which is a licensed situation under the Financial Service Acta 2013 or the Islamic Financial Service Acta 2013, and which is not member institutions under the Malaysia Deposit Insurance Corporation Acta 2011. G. In this case of the company which is an operator of the designated payment system under the Financial Service Acta 2013 or the Islamic Financial Service Acta 2013 or the Central Bank of Malaysia. H. The register on the ground specific in the paragraph 465(1)(d). I. In this case of a member institutions under the Malaysia Deposit Insurance Corporation Acta 2011, the Malaysian Deposit Insurance Corporation mentioned in section 99 of the Acta. Okay, the conclusion who is the right to petitions is the company, the creditor, the contributory, the minister, the liquidator, BNM, and register. In section 466, a company shall be deemed to be unable to pay its debt if the company is indebted in a sum exceeding 10,000. A creditor by assignment or otherwise has served a notice of demand. Written demand has been delivered by within 21 days. Judgment has been obtained, but the execution is not certified in whole or in part. The court certifies that the company is unable to pay the company's liability more than its assets. A petition to wind up a company shall be filed in the court within 6 months from the expired date of the notice of demand.
Effects of winding up on the creditor. 1. Any disposition of company's property other than by liquidator is void unless less court orders otherwise. 2. Creditors cannot enforce any judgment or order. 3. Legal proceeding cannot be brought vs the company. On the company is prevented from carrying on its business. Company cannot deal with its property. Director. All the powers of the directors shall cease upon the winding up of a company. The liquidator will take over the administration of the affairs of companies winding up. On the employees. Normally, in case of voluntary winding up, employees will not be dismissed unless the company is insolvent. However, in case of compulsory winding up, publication of the winding up order serves as a notice of dismissal to the company's employees.